Estate administration is the process of managing and settling a person's estate after they've passed away. It ensures that assets are distributed according to their wishes set forth in their will or by state law through what are called intestacy laws if there is no will. It's the comprehensive process of collecting assets, paying debts, accounting to the state for tax purposes and to the beneficiaries, and ultimately distributing the remaining property to the beneficiaries or their heirs. It sounds straightforward, and it can be at times, but due to the complex nature of how we live our lives, estate administration can also be very complex. So let's break down some key terms and explore how these terms relate to one another. Probate is a legal procedure that gives authorization to another person, called the executor if there's a will, or called an administrator if there isn't a will, to take any action on behalf of the estate, to get information from banks or other financial institutions, to transfer assets, to negotiate and ultimately settle any debt, to pay out distributions to the beneficiaries. And this person is bound by certain laws that govern this process. In Pennsylvania, these laws are cited as the Probate, Estates, and Fiduciaries Code, often called the PEF Code. This code sets forth all of the laws governing estate administration, trust administration, probate, and even how fiduciaries during our lifetime, like agents under a power of attorney, must go about serving in these various roles. So a key point, probate is just one part of estate administration. It's the court's involvement in overseeing the transfer of assets, but estate administration encompasses much more. Probate may be required if assets are in the decedent's name alone, or if there are no beneficiary designations on certain assets. So certain types of assets like jointly owned property or accounts with beneficiary designations, transfer on death designations, pay on death designations, or in trust for designations, all of these assets may avoid probate entirely. But even if they avoid probate, they are still very much part of estate administration. And the reason, particularly in Pennsylvania, is that even assets that pass outside of the probate process are subject to tax. And the state requires proper accounting in the form of a tax return to report these assets and pay tax on them. The role of the executor is a critical component of estate administration. An executor named in a will is responsible for carrying out the decedent's wishes. I'm going to cover a brief overview of the role of the executor in this video, but I have an entire video dedicated to this topic. So I'll put a link to it in the description of this video if you'd like to check that out. By the way, if you find this content useful, please consider subscribing to the channel by clicking the subscribe button below. The executor's duties often include the following. So 1, inventory and appraise assets. So the executor must identify and collect the decedent's assets, including real estate, financial accounts, and personal property. Number 2, pay debts. So the executor is responsible for identifying and settling all outstanding debts of the decedent, including taxes. And number 3, distribute assets. So finally, the executor's role is to distribute assets to the named beneficiaries in accordance with the will. Now, again, if there isn't a will, this person is the administrator and the assets are distributed according to intestacy laws. I want to draw a distinction, but also highlight similarities between estate and trust administration, particularly in the context of Pennsylvania law. So the PEF code, which I referred to earlier, requires almost identical obligations and duties for the executor of an estate and the trustee of a trust. So trust administration refers to managing assets held in a trust, a legal entity that's designed to hold property for beneficiaries. So I'm not going to go into the nuances of trust, but I bring this up because in a lot of states, the probate process is costly and time consuming. And so people create living trusts, revocable trusts, to avoid probate. Pennsylvania is a bit different. The PEF code sets forth rules that are almost identical for estate administration and trust administration. So the process turns out to be almost identical. So just to give you a quick glimpse into trust administration in Pennsylvania, the PEF code sets forth requirements for the trustee, duties of the trustee. So the trustee is required to provide notice to personal representatives of the decedent's estate. They're required to provide notice to the decedent's spouse. They're required to provide notice to the decedent's adult children, required to provide notice to beneficiaries of the trust, required to respond to requests for information from the beneficiaries. The trust is subject to the decedent's creditor claims. So just like in estate administration, where the executor is required to negotiate and ultimately settle the decedent's debt, trustees under a trust also have the same obligation. Trustee is required to advertise the trust to create a statute of limitations against creditor claims. And finally, the trustee may retain trust assets for payment of debts, expenses, and taxes. And so while trusts are often touted as a better alternative to a will, this isn't really true in Pennsylvania, because the trustee, just like an executor under a will, is going to retain assets until they've made sure that all of the affairs, all of the things that they're required to do are taken care of. And so the trustee has that same obligation. So they're not, yes, the trust assets avoid probate and you don't have to pay probate fees, but in terms of ease of administration, it's identical. It's the same process. In Pennsylvania, the probate process is relatively cost-effective, and because the rules for trust administration are so similar, it's far less common in Pennsylvania to create a revocable living trust. Most people decide to structure their estate planning using a will. Many tasks in trust administration, like paying debts, distributing assets, and managing taxes, are also part of the estate administration process. The main difference is that trust administration usually bypasses probate because the assets are already owned by the trust. A caveat to that, however, is that if the decedent has not fully funded the trust, and what that means is if there are assets that were still owned in the decedent's individual name and weren't titled or retitled into the name of the trust, then the estate is still going to have to be filed through probate because there are assets that need to pass and the trustee doesn't have authorization to manage assets that were outside of the trust. So this is actually a common occurrence in Pennsylvania because revocable living trusts are so uncommon. You have these situations where there are one-offs where people created them for some reason. They thought they needed them. So they create them, maybe they partially fund it, but not fully. Person dies, and now you have trust administration and probate. If there's a will, estate administration ensures that it's followed. If there is no will, state law determines how the assets are divided, which often still requires the same administration process. For smaller estates, some of them can bypass formal probate, depending on state law, but still require some administrative work to settle debts and distribute assets. So in Pennsylvania, we have what's called the small estates affidavit, but the process is very similar to probate. So a lot of attorneys who administer estates in Pennsylvania, even with a small estate, they'll just decide to go through probate anyway because it's a process that they're more familiar with, and the rules and duties and regulations are fairly similar. Estate administration is an essential process. It ensures that everything is handled efficiently after someone passes away, whether through probate, trust administration, or other legal processes, and that things won't crop up later in time that would impose a heavy burden on a decedent's loved ones.